In the last order, sir, court has passed, issued a direction for filing a written objection, sir,
Yes,
which
state-
have been not received.
सर देयर इज नो नीड टू फाइल रिप्लाई. मैं आर्ग्यू करने को तैयार हूँ. इनकी पिटिशन में सर इन्होंने 3 रिलीफ मांगे हैं. काइंडली सी पेज नंबर 10 and 11, which is a prayer clause of this petition.
Yes.
A, B और C 3 पॉइंट्स हैं इनके. ए में इनका ये कहना है कि सेट असाइड द इम्पिंग ऑर्डर डेटेड 11/2/2022 and 23/7/22 annexure A and C passed by the special judge SC/ST Act ADJ 1 of District Court Indore in session trial number so and so and release the bail surety amount. इसमें सर इनके जो ए और सी डॉक्यूमेंट है ये इनको अपीयर होना था ट्रायल कोर्ट में डेट पे, ये अपीयर नहीं हुए तो कोर्ट ने इनकी जमानत कैंसिल करके कर दी. उसके बाद जब नेक्स्ट डेट पे अपीयर हुए तो उनको वापस से कोर्ट ने पिछली जमानत कैंसिल हो चुकी थी तो नई जमानत बेल बॉन्ड भरवाया 1 लाख रुपए का. तो जब तक वो अब ये चाह रहे हैं कि वो जो 1 लाख रुपए का बेल बॉन्ड है वो रिलीज हो जाए. जब तक वो एक नई श्योरिटी कोर्ट को नहीं देंगे या बेल बॉन्ड नहीं देंगे तो वो बेल बॉन्ड रिलीज कैसे हो सकता है.
What happened to the previous bail bonds?
वो कैंसिल कर दिया था कोर्ट ने क्योंकि ये अपीयर नहीं
Seize कर दी,
Whether
forfeited.
They have been forfeited.
Yes, sir.
फॉरफिट कर दिया था और 2000 रुपए का इनको फाइन
No,
लगाया
but
था.
हाँ.
I remember the order sheet was not in very
Clear,
Clear
sir.
words.
It's not clear, sir. I have approached the trial court. Sir, can I say one thing, sir?
सर अनेक्शर ए है 19 नंबर पे.
Sir,
Connection?
can I say one thing, sir? I
Yes.
was never been absent. I was requesting the court to conduct the hearing through video conferencing, sir. And there was a transfer petition pending under section 408, sir, before the principal district judge. And that was listed for 15th February 2021, sir. 15th February 2022, sir.
Yes.
And on 11th February, my bail was cancelled, sir. According to section 407(6), sir, if any transfer petition is pending, the matter should be adjourned, sir.
Which provision you are relying?
So CRPC 407, section 6, sir.
Let us see that 407.
So no adverse order should be passed. When the
Let us
accused
see.
is saying
Have
that,
you got the book?
sir, I remember, sir, I have read it.
Mr. Ashok, if you are arguing
It should be
without,
stated, sir. It should be stated. You can see the section 407, subsection
if
6.
you are
sir.
saying, let us see that
Sir.
407.
It is, sir. It is also understood, sir. Judge should not pass any adverse order when the accused is saying that the
No,
judge
no,
is biased.
That is a different thing. You said law says like that.
Yes, sir.
When you
can
say
see.
that law
Yes, sir.
like
407(6),
And
sir.
what should be understood by the presiding officer,
Yes,
that is a different thing.
Sir, comment was
We
given
go
to
by the law.
sir.
Which provision
many
you are saying?
सर ऐसा कुछ भी नहीं है इस प्रोविजन के अंदर जो
That's
बता
why
six में देखिए.
we
state. It should
just
be
let
stated.
him argue. 40.
It should be stated. 407 subsection 6.
हाँ हाँ
देखिए.
देखिए
पढ़ दीजिए आप. Trial should be stayed.
तो ट्रायल आपकी स्टे थी क्या? ट्रायल का स्टे था.
ट्रायल स्टे नहीं हुआ, मेरा अरेस्ट वारंट निकाल दिया. वन मोर थिंग सर, आई हैव रिक्वेस्टेड फॉर वीडियो कॉन्फ्रेंसिंग एंड ड्यूरिंग दैट टाइम दिस ओमिक्रॉन वाज गोइंग ऑन सर.
देखिए अभी तो
11th
जो
February.
आपने कहा उसमें कहीं ऐसा
सर
नहीं
बहुत
है।
सारे हैं सर. मैंने 317 एप्लीकेशन में लिखा था. पर्सनली आई हैव फाइल्ड 317 एप्लीकेशन.
Mr. Ashok, it would be very difficult to decide your case
सर 317.
unless first you hear the query of the court,
सर श्योर.
answer it, then only we can
Yes, sir, sure,
decide
sir.
something.
यस सर.
First you said that the provision says
Yes,
if the
sir.
application is
Yes, sir.
for transfer,
यस सर.
there is no such provision automatic stay.
हाँ, इट्स रिटर्न सर. इट शुड बी स्टेट सर.
If the High Court is satisfied,
यस सर.
that is a different thing, subsection 6.
सर if you see the page number 41 sir. Page number 41 and
And-
42 sir.
And now first thing, because you have come
Yes sir.
in under section 482 now,
Yes sir.
yes, what repeatedly we are asking from the last dates also,
Yes.
we are not able to understand what relief you want from the court.
Sir, there is no documents records
Because-
available in the trial court's record to prosecute me
Which
sir.
is,
That is
read-
statement of witness 161.
hmm,
FIR is not being named sir. Statement of witness 161 is not there. Statement of 164 is not there. Documentary evidence is not there sir. Now, when these documents are not there, I am not the accused sir. I am being forcibly made accused.
yes.
So let the counsel, public prosecutor submit this document, which I am asking in prayer 2, sir. So it will prove that I am the accused or not, sir.
You want which documents? Come
Sir,
to
copy
B,
of FIR in which a complaint is made against me, sir.
FIR.
Yes, sir.
Copy of FIR.
Yes, sir.
One.
Thereafter, statement of witness 161. During the trial, I should cross-examine the accused.
Statement of witnesses.
161. During the trial, I should cross-examine that witness, sir. Thereafter, sir, statement of witness 164, which was submitted on 19 Jan 2017, when I was in the judicial custody. So that was submitted in the court's record, sir. It is in the order that 19 Jan 2017, statement of witness 164
Have
is being
you-
given.
Just listen. B, read your prayer B.
So prosecution be directed to submit documents in terms of section 207 of CRPC, that is statement of witness recorded under section 161 and 164 of CRPC, and documentary evidence under section 173 subsection 5 of CRPC, on which prosecution is relying upon to prosecute petitioner under section 420, 467, 468, 471, 201 and 120B of IPC before this honorable court as per the direction issued by the Honorable Apex Court in MA number 1045/2021 passed on 14th March 2022 in SLP number 1189 of
Have you
2019.
made, next query,
Yes, sir.
have you made any application under section 207
Sir.
before the court?
Yes, sir. It was dismissed on 15th
sir,
June.
Just,
लेट मी इंटरप्ट सर, अगर आप कहें तो मैं उनका पूरा केस समझा देता हूँ.
नहीं, let him,
सर आप केस मत समझाइए, आप डॉक्यूमेंट दे दीजिए, बस डॉक्यूमेंट दे दीजिए.
just 15-1, when did you,
It was 15 June, it was dismissed. Again, I have filed, sir, application under section 91/207 yesterday, sir. After 15 June order, I applied for the certified copies, saying that provide me the documents in terms of section as per the
what
order.
happened to that application that has been rejected?
Sir, that was rejected. So 15 June, it was rejected, sir.
If it was rejected, have you challenged that?
Sir, I am challenging the same 482, sir.
कहाँ पर?
इसी कोर्ट में, sir.
पढ़िए, कहाँ आपने चैलेंज किया?
Sir,
That's why we,
sir, it is in Annexer B, page number 21, sir.
hmm?
Page number 21, sir.
Page 20. Mr. Ashok, you have to challenge it in the,
Sir, it is in
Relief.
page number 21, sir.
unless you challenge, you ask for the quashing of that order. How we will examine, how we will grant you relief if you have not challenged that order?
Sir, it is in page number 21, sir. Annexer B.
That order was passed by magistrate.
No, sir. It was ordered by the special judge, Sri
Special
Manoj Kumar.
matter is being tried by a special judge.
Yes, sir.
So have you have not challenged that order?
Sir, same thing. I am challenging under the 482, sir.
Where you read, these are the reliefs now, A, B,
Sir.
C, D.
Yes, sir.
Read where you have challenged that order.
Sir,
सर ये वो
Because-
चार्ज जो लगे थे वो रिवीजन में चैलेंज कर चुके हैं, रिवीजन डिसमिस हो चुकी है. उसकी इन्होंने सुप्रीम कोर्ट में एसएलपी भी लगाई थी, वो एसएलपी भी डिसमिस हो चुकी है.
sir, in place of going on the back record, because some mistake has been committed by the court, so we should not argue on that matter, sir. We should argue in the present matter what is being kept after the Supreme Court has told in MA number
We are
1045.
asking Your grievance, you said you are not being supplied.
Yes, sir.
Documents.
So I have kept it before the Supreme Court in MA number 1045. So Supreme Court has issued a direction to the trial court to provide the documents in terms of section 207. I am only requesting, sir, that I should be given these documents.
Thereafter,
Sir,
you
document
made an
तो दिए जा चुके
application.
Sir, you give it
Mr.
one more
Salwan.
copy to me, sir.
Mr.
You give it one more copy to me.
इन्होंने फाइल
Mr.
करा.
Ashok, after the Supreme Court order,
Yes, sir.
have you made any application under section 207 before?
Sir,
the
it was
court?
pending. Sir, it was pending since long time. And due to that application, arrest warrant was issued against me. Because they were unable to give the documents, so they take a revenge. They have issued a arrest warrant against me. That let
Then
him
what
come here.
happened- What happened to your application after the
So
Supreme?
on 15 June it was dismissed, sir.
So have you challenged it?
Sir, in the same 482
No.
I am challenging, sir.
That we don't.
I am asking the same document in para B, sir.
कहाँ B में कहीं बताइए ना.
Sir,
When
मैंने वो
you are
mention
asking a direction, but you have not challenged any word that 15/6/2022 order be
Sir, I will
quashed.
amend. Sir, I will amend the petition. I will submit it saying that I am challenging the 15 June order, sir. because I have not mentioned it, because I am not an advocate, sir. I can keep the facts before the court. I can assist the court with the fact, so that court should not commit a miscarriage justice.
We will grant you time, but
Sir,
if you are
until then,
able-
sir, I will request a prayer number
आपकी
1.
जो ग्रीवियंस है,
हाँ sir.
आप अगर 15 जून 2022 ऑर्डर में भी राइट और रॉन्ग,
Yes.
बट यू हैव टू चैलेंज दैट ऑर्डर.
So because I have mentioned in the para B the same thing which was demanding a 15 June order, sir.
Yes.
It was Supreme Court's order
You
in
want
MA number.
you want time.
Sir, I will amend this, sir. By the time, sir, prayer number 1 should be considered, sir.
क्या what is prayer number 1?
Sir, for setting aside the order of 11th Feb, sir. Only my request is
that
this,
we
sir.
will consider.
Sir,
because-
sir, everyone is looking,
We
sir. So many people are watching and looking that a retired soldier of the Indian Armed Force will be given justice, delivered justice
Mr.
today, sir.
Ashok, we are not impressed by that.
Sir, okay, sir.
YouTube,
Yes,
etc. That just should not be influenced by all
No,
that.
sir, I am not influencing, sir. I am
Yes.
telling the fact. I have told the fact, everything.
We are trying to
First of all, no
find
conjugal.
out your grievance
Yes, sir.
and to do the justice.
Sir, first of
that-
all, there is no conjugal offence is made against the
But
petitioner
first-
until he is given documents, sir.
We are entertaining you only because otherwise, if the liar would have appeared, we would have asked to confine one relief. You can't ask multiple relief in a one petition because judge can't decide multiple grievances. So you have to file separate applications.
Sir,
That's
I
why
will
we
file
are
a separate application for 15 June order, sir.
asking. Yes.
I'll file it. Sir, prayer number 1 should be considered today, sir.
So you are not challenging B part.
Sir, I will file a separate petition challenging the
You
15
want
June.
to amend this petition or you want to file?
Sir, if you give the permission, sir, I will amend
No,
the
no,
petition.
we will grant you. We will
Sir,
not.
I will amend the petition, sir. I will amend the
discussing,
petition.
saying anything to you, that doesn't mean that we are passing an order against you.
Sir, sir,
We will
sure,
give
sir.
you opportunity.
Sir,
Now
sir.
let me make the query to the state council.
Sir, sure, sure.
Yes, Mr. Sanotia,
Sir.
his grievance regarding supply of documents.
सर इनको डॉक्यूमेंट ऑलरेडी सप्लाई किए जा चुके हैं. इन्होंने खुद ने अपने कंपाइलेशन में फाइल किया है एनेक्शर जी पेज नंबर 57. उसमें बाय मेल जो डिस्ट्रिक्ट जज हैं उन्होंने इनको मेल के थ्रू ये डॉक्यूमेंट सारे डॉक्यूमेंट जिन्होंने मांगे वो सप्लाई किए हैं और ये इन्होंने खुद ने अपने कंपाइलेशन में फाइल किया है. फर्स्ट ऑफ ऑल. सेकंड सर, एक 19/11/2017 की प्रोसीडिंग्स हैं. इसके अंदर
नहीं,
स्पेसिफिकली
इन्होंने ये
प्रोसीडिंग में
15/6 का
सर, आप
ऑर्डर
उसमें
का
से 161 के स्टेटमेंट दिखा दीजिए जज साहब.
सर एक सेकंड
निकाल के
एक
दिखा
सेकंड,
दीजिए,
आप पूछ सर 50 पेज नंबर 57.
15/6 का ऑर्डर है रिकॉर्ड पे
15/6 का ऑर्डर नहीं है सर.
जो ये कह रहे हैं रिजेक्ट कर दिया
नहीं
इनके।
सर, इनको तो 19/7/2022 को डॉक्यूमेंट दे
तो
चुके
फिर
हैं.
उसको करिए भाई, करना दीजिए, अमेंड करने. दैट्स व्हाई वी
सर सब
वांटेड.
डॉक्यूमेंट इनको मिल चुके हैं. अब सेकंड
सर,
सर ये बोल रहे हैं
एक डॉक्यूमेंट वो बता देंगे.
ठीक है, वी विल
Sir,
सर्टेन.
we will
ये-
decide
ये
the
जो
court
सारे
by
documents हैं-
one document. He will produce it in the court. I will see that
सर
document.
लिखिए.
मेरा ये कहना है
Sir,
सारे
आपने
डॉक्यूमेंट जो हैं,
personally, sir,
ये चालान का हिस्सा है.
Sir, judge should-
164 भी FIR भी. एक सेकंड
Judge
एक
should
सेकंड एक सेकंड जरा.
personally see the document, sir. And
वी विल
personally, sir,
Personally,
I will
sir.
also see the personally. The
लिखिए.
court will also see the personally the documents.
पहले
Sir.
आप उसको चैलेंज कर दीजिए.
हाँ सर.
श्री अशोक
सर, प्रेयर नंबर 1 का आज डिसाइड कर दीजिए सर.
अरे ऐसे इन पीस मील वी कांट
सर, बहुत दिन हो गए सर, बहुत दिन हो गए सर.
if
प्लीज सर.
petition is to be allowed or dismissed, it can't be in part that for relief number 1 it is dismissed, for relief number 2 it is allowed. It can't be heard like this. So either
Sir, I will file a fresh petition for this thing, sir.
This thing,
For the
लिखिए.
documents. Sir, prayer number 1 को सर जो भी डिसाइड कर दिया सर.
अच्छा, now first come to another
हाँ, sir.
C, questioning of the charge.
So these both I will take it in a fresh petition, sir.
No, charge, he says that the revision has already been dismissed.
Sir, that's why I am requesting the court, sir, not to go on the back record because court will be misleaded, sir. Because all the orders was passed.
Not misleaded. If this order,
Sir, it was a
we are
miscarriage
asking you
justice, sir.
a very simple query.
Sir, I have filed a
Whether this
revision. Sir, can
Mr.
I?
Ashok, first answer.
Yeah, sir.
Listen to the query of the court, then
Yes.
you will be
Yes,
able
sir.
to answer.
Sir, sir.
Whether this order, which in prayer C,
Yes,
you have asked for the quashing
sir.
of the order dated 7/2/2017, Have you
Sir.
challenged it in the revision?
Sir, I have not challenged. My advocate has challenged it and it
Oh,
was withdrawn.
advocate is always acts on these.
Yes, sir.
सर ये उसका
Sir.
So
ऑर्डर
you can't say
ये ऑर्डर है उसका
Sir, it was withdrawn. It was withdrawn, sir.
withdrawn.
Yes.
So withdrawn if without liberty means it is
Sir,
dismissed.
I have filed it
That is
again.
legal.
Sir, I have filed it again. After,
Where?
after coming out from the jail, I have filed again criminal reason. It was told that you are not granted liberty to file a criminal reason.
Same thing which
Sir.
this court is also saying.
Sir, that is, sir, that is there. But court can't proceed with the person without giving the documents, sir. It will be a violation of principle of natural justice. So I may be given a liberty to
Against
file
the
a
order of
WP.
this court, you went to Supreme Court also.
Sir, Supreme Court has recently passed the order to give the documents in terms of section 207.
No, not nothing about this order of the
No,
charge.
no, nothing about the criminal reason, nothing, sir.
Chalo.
I,
So
in
we
the
will
same
confine
SLP,
it only to relief clause 1.
sir, sir, in the same SLP, I went with a miscellaneous application that documents are not being provided, and no person can be prosecuted without giving the documents in terms of section 27. So, Supreme Court directed the trial court to issue the documents in terms of section
Yes.
207, which is in page number, sir,
Yes.
page number 51, sir. The court shall, it is being written, the court shall also give copies of documents in terms of section 207 of the code as prayed by the accused. It was, judgment was given on 14th March 2022. So, sir, now we will start from this stage when the Supreme Court, Apex Court has given the direction to issue the documents in terms of section 2. It was delivered on 14th March 2022. So, no use going towards backwards, sir. We will start with the fresh from 14th March 2022 onwards, which the Apex Court has passed the order, sir, by the three bench Justice Uday Umesh Lalit, S. Ravindra Bhatt, Justice.
That is not
Sri-
required.
Sir.
You need not
So
to
we will
mention the
start
names.
from this stage, sir.
So we
after
are
14th
asking
March.
only thing because you said,
Sir.
what about B and C? You want
Sir,
to,
same BNC, and I'm talking about the Supreme Court judgment. Supreme Court
Oh,
judgment has passed on 14th March 2022. So we will
so
why
we are
we should go
making
back,
very simple query whether in this petition
sir? Criminal division.
you are confining your challenge to B and C also, or you will
Sir, I
withdraw
will
this.
file a fresh petition with this Supreme
Likhye.
Court judgment.
Likhye.
Until then, sir, I am not a, means I can't be prosecuted, and the warrant was issued, it is a wrong, sir. So I
We
request
will-
to set aside, sir, the order.
So you will confine it to only A.
Now presently A, because that order should be set aside so that I can get a money back. 1 lakh rupees
Order
is
will
being
be set
forfeited.
aside or not, that will be
Sir, court will decide.
decided
That
after.
court will
hearing.
decide, sir.
लिखिए applicant in person Sri Vishal Sanotia GF for the state. लिखिए at the outset counsel for the applicant submits that he will confine the present petition only in respect of relief claimed.
Sir, can I please, sir? Sir, one more thing, I wanted a liberty to file a writ petition for violation of principle of natural justice. Because,
That liberty, we always grant liberty only in
sir, in
accordance with
place
the
of,
law.
along with that, I will
You
file
are free, Mr. Ashok, you can file petition as many as you wish.
no, sir,
If it is
because,
permissible under the law.
because when the documents are not there, it
Liberty
is a
is
violation
not
of
granted,
principle of
liberty
natural
will be
justice.
granted only in respect of B and C, which is before me.
Sir, this is the same thing, it is a violation of principle of natural justice
Oh,
if the documents are not given in under section
सर
207.
आप-
सर मेरा ऐसा कहना है कि ये जो डॉक्यूमेंट मांग रहे हैं ना शायद ये हो सकता है आप भी कंफ्यूज हो रहे हो कि
Sir,
ये
मैं
मांग
confused,
एक
मैं
सेकंड
victim-
FIR ये मांग रहा है 27 मेमो ये कोई भी डॉक्यूमेंट चालान से अलग तो होंगे नहीं कि वन चालान अलग होगा 164 अलग होगा FIR अलग होगी चालान का ही हिस्सा होंगे ना चालान उन्होंने खुद ने फाइल कर रखा है इलेक्शन आई पे
सर,
अभी तो मिस्टर सनोतिया वी आर
सर,
ट्राइंग
मैंने
टू
फाइल कर
डिसाइड
दिए चालान.
confined to relief class A only and prays for withdrawal of reliefs in respect of B and C. उसके पहले लिख दीजिए in the present petition the applicant has prayed following reliefs पहले कोट कर दीजिएगा फिर लिखिएगा at the outset से and prays for withdrawal of B and C with liberty to file fresh petitions in accordance with the law. Yes, in view of the aforesaid, the present petition is entertained only in respect of relief A. Yes, अब argue करिए relief A पे.
Sir, relief A, I was never absent. I was continuously requesting that time
Just
Omicron
11/2.
February. That time some
Where is
Omicron.
that order? 11/2/2022 and 23/7.
So
Yes.
during that period, Omicron was going
Where
on.
is that order? You are challenging that order, then
So page
first we
number
have
19.
to, huh?
पेज नंबर 19 एनेक्शर ए.
19.
हाँ, जो उन्होंने चैलेंज किया है एनेक्शर ए, वो है पेज नंबर 19 पे.
ये इससे नहीं जाइए. ऑर्डर की डेट क्या है?
ऑर्डर डेटेड
23rd July,
23/7/2022. 23/7/2022.
Sir,
Yes.
during the February, sir, Omicron wave was there, and the whole courts of India were working through video conferencing. So I have requested the court to conduct the hearing through video conferencing. My application under section 207 was pending. Transfer petition under section 408 was pending. So my humble request was that to conduct the. I have even sent an email on that day for conducting. I have called up the council here in Indore to arrange for the video conferencing.
नहीं, just one by one.
Yes, sir.
Mr. Ashok, otherwise
Yes, sir.
we will not be able to
Sir,
decide.
sir,
First, where is order 11/2/2022?
11th to it is in page number 31, sir.
31.
Sir, I will read out the order, sir.
Just a minute. Let us. Page 30,
2, sir.
11/1. Yes.
Sir, in page number 32.
Yeah, what has been? Yes.
Sir, from page number 32, where I have made a request, in para 3, sir, पेज नंबर 32, अभियुक्त अशोक के आवेदन का सार्थ्य यह है कि उसे अभियोजन से जान का खतरा है और अभियोजन उसे एनडीपीएस और पास्को एक्ट में झूठे मामलों में फंसाने की धमकी भी दे सकता है.
Yes.
अभियुक्त अशोक हुबली कर्नाटक का स्थायी निवासी है और न्यायालय में उपस्थित होने से उसे खतरा और मानसिक प्रताड़ना और आर्थिक क्षति होगी. इसके अतिरिक्त आवेदन में दस्तावेज प्रदान किए जाने संबंधित अनावश्यक तथ्यों का उल्लेख किया गया है. उल्लेख किया, लेकिन अभियुक्त ने अपने आवेदन में अपनी अनुपस्थिति को उचित ठहराने के लिए 2 न्यायमनियों हिरेमगलपुर पार्श्वसारथी सामला एंड एक्सेट्रा वर्सेस स्टेट ऑफ बिहार.
Yes.
Yes, sir. And Maharashtra, that will skip it, sir. And उक्त न्यायाधीशों के आलोक में उसने विचारण के समस्त स्थितियों को व्यक्तिगत रूप से उन्मुख प्रदान किए जाने और विचारण को वीडियो कॉन्फ्रेंसिंग के माध्यम से संचालित किए जाने का अनुरोध किया गया है, सर. अभियुक्त के अधिवक्ता श्री सुशील कुमार शर्मा ने यह किया कि आवेदन में उल्लेखनीय तथ्य उनके तर्क हैं, वे प्रत्यक्ष से कोई तर्क नहीं करेंगे. विशेष लोक अभियुक्त ने आवेदन का प्रबल करते हुए तर्क किया कि अभियुक्त अशोक ने नित्य एवं असत्य आधारों पर अभियोजन पर गंभीर आक्षेप लगाए हैं जिनमें लेश मात्र भी सत्यता नहीं है, अतः आवेदन निरस्त किया जाए, सर.
Yes.
Sir, this along with that I am requesting the video conferencing.
First you read, then argue.
Sir,
उभय पक्ष के
उभय पक्ष के तर्कों से आलोक से अभिलेख का परीक्षण किया गया. अभियुक्त अशोक दिनांक 5/2/2020 को न्यायालय में व्यक्तिगत रूप से उपस्थित हुआ. दिनांक 13/1/2021 को वो वीडियो कॉन्फ्रेंसिंग के माध्यम से उपस्थित हुआ तथा उसके उपरांत उक्त अभियुक्त ने न तो व्यक्तिगत रूप से और न ही वीडियो कॉन्फ्रेंसिंग के माध्यम से उपस्थित हुआ है. न्यायालय द्वारा विगत तिथि पर आदेशित किए जाने के उपरांत भी वह आज उपस्थित नहीं हुआ. उसकी ओर से कि जो न्याय मनी पेश किए हैं उसके अभियुक्त ने यह अंडरटेकिंग दी थी कि जब आवश्यकता होगी वह व्यक्तिगत रूप से उपस्थित हो जाएगा, लेकिन इस प्रकरण में अभियुक्त अक्षेक ने कोई भी अंडरटेकिंग ही नहीं दी है. इस प्रकरण में 11 अभियुक्तगण हैं, लेकिन किसी भी अभियुक्त द्वारा ऐसी याचना नहीं की जा रही है. न्यायालय के आदेश का पालन न करते हुए अभियुक्त अशोक ने निरर्थक और काल्पनिक आधारों पर अभियोजन का आक्षेप लगाते हुए आवेदन पेश किया है. उसकी ओर से प्रस्तुत न्यायमनियों की प्रतिलिपियां न्याय सिद्धांत आधार योग्य होने से इस प्रकरण के परिस्थितियों में लागू नहीं होता है. अतः अभियुक्त अशोक की ओर से आवेदन अंतर्गत धारा 317 दंड प्रश्नहीन होने से निरस्त किया जाता है. अभियुक्त रमेश चंद्रकांत और अशोक द्वारा प्रस्तुत जमानत मुचलके जब्त किए जाते हैं. उक्त अभियुक्त गण की उपस्थिति हेतु उनके विरुद्ध गिरफ्तारी वारंट जारी किए जाए. सर, देयर वाज अ एप्लीकेशन अंडर सेक्शन 207 वाज पेंडिंग 91 for the document. For that they are saying I am asking the documents, unnecessary documents which is not available in the court's record, which has been told by the trial court.
Where is your application under section 317, which was
Sir.
rejected?
Sir, 30, it is,
317.
sir, it is in 35, sir. Page number 35,
Yes.
sir. That the above noted matter is pending trial before the Honorable Court under section 91 CRPC for summoning of produced document as per section 207, 2, 3, 4 and 5 of CRPC and fixed for 11th February. That the applicant Ashok B. Nagarngar request Honorable to grant exemption from physical appearance on all days due to under-mentioned grounds and reasons. Applicant Ashok has a risk to threat to life from prosecution. Even the prosecution has threatened that false case will be filed against the applicant under NDPS and PASCO Act. If applicant takes any legal action against the prosecution, and at present writ petition number 4295/2018 is pending before Honorable Bombay High Court against the prosecution for kidnapping and for registering fake and false criminal case against applicant. I have clearly mentioned in para A that there is a
Just a minute. This order was passed on 11/2.
11-2, sir.
Your application for...
Yes, sir. There is a petition,
No, no.
writ petition pending against the prosecution in Bombay High Court, sir, with MCRC number 4295/2018, sir, for kidnapping and registering a fake criminal case, sir. And already the non-bailable warrant was issued against the ASP Vinay Prakash Paul and ASP Amrinder Singh and Constable Ajit Singh Yadav.
Yes.
All the three accused respondents were issued the non-bailable warrants, bailable warrants, sir, with a sum of rupees 15,000, sir.
Yes.
Applicant Ashok is a permanent resident of Hubli, Karnataka, and travelling from Hubli to trial court at Indore will take 5 to 6 days for making personal appearance, which will cause risk, undue hardship, and mental torture.
Mr. Ashok,
Sir,
after this
sir,
order,
I will complete this, sir. My application.
11/2/2022,
Sir,
you are participating in the proceedings.
sir, I am
After
regularly I am
11
requesting for conducting the video conferencing. After that, after this order, I have received the police protection from Bombay High Court, but it was not been given because I am staying in Karnataka. So I am not staying in Bombay because the initial this writ petition filed in Bombay High Court, sir. So I have approached Bombay High Court after this thing that I should be provided police protection. So Bombay High Court has issued the direction to the DCP for granting of police protection. So I was not staying in Bombay, so I left to Karnataka, so that I have not pursued.
Yes.
So further it says hardship and mental torture and also financial loss applicant
you
during the
need not
present
to-
situation of COVID-19 pandemic.
You need not to at present you are getting police protection.
No, sir. Actually, now the court has also told, they have made a remark, ASP Vinay Prakash Paul, and they have made a remark, nothing will happen to him in the High Court, Bombay High Court, if he approach, and if he want any police protection, he can take from the Indore High Court.
So have
So
you
now-
applied?
Sir, I have not applied it because I am now, sir, I am a soldier, I am not fearing, I will die, sir. But already I made a letter to the President, Prime Minister, everywhere, that saying that if anything happens to me in this case, these police officers will be held responsible.
Yes.
In the Bombay High Court also I have made it, so I am freely moving now, sir. Now whoever interfere in my case, sir, I will file a contempt criminal against them. The case is again filed, a contempt of court case been filed against the Deepak Gupta in Supreme Court, sir. With a diary number, I can show the diary number also, sir.
No, that is
But
different.
I don't have any fear now, sir, because I have lost faith.
Yes.
Because someone is interfering in my case, they are not able to submit the documents, sir, which I am demanding.
Yes.
Now, recently, sir, recently
No,
in
at
page
present,
number, sir,
Mr.
I will,
Ashok,
I
at
will
present we are examining.
sir,
you are
what is the
free
trial
one-
court judge is making in recent? When I have asked the same documents on the order of 15 June, it is in page number,
No.
sir, please, sir, allow me,
Mr.
sir,
Ashok,
page number 231, sir. Page number 231, I have requested the copy of statement of witness recorded by investigation officer under section 161 of CRPC.
That you have
Sir,
said
sir,
you will
please, sir, one-
agitate separately.
Sir,
You
I
have
will
said-
accept what the trial court judge has told, sir. इस नकल आवेदन में चाही गई प्रतिलिपियां प्रदान करना संभव नहीं है क्योंकि ऐसा दस्तावेज अभिलेख पर नहीं है. When the trial court judge is saying it's not there, but the public prosecutor is saying it is there in the charge sheet.
Yes.
So trial court has failed to search in the charge sheet, sir, in the entire charge sheet of the court.
सर, इन्होंने मांगा था कि वो FIR दें जिसमें मेरा नाम लिखा है.
सर मैंने
FIR में
स्टेटमेंट ऑफ
इनका नाम
विटनेस
है ही
मांगा
नहीं.
है. सर मैंने स्टेटमेंट ऑफ विटनेस
ये
मांगा है.
27
आप
के
प्लीज
मेमो भी बने.
सर प्लीज आप पेज नंबर 31 पढ़िए. पेज नंबर 31 निकालिए, क्या मांगा है मैंने. Copy of statement of witness recorded by the investigating officer under section 161 of CRPC which directly concerns and relate to the accused Ashok being an orderer in session trial number 699 of
That is-
2016
that
as
you have-
mentioned, sir, as mentioned in para 5 of the order
That
sheet
you
dated
have
15
already
June
said.
2022.
Mr. Ashok, you are not challenging it in this case.
Sir,
You have said
I
you
have
will-
kept it because I was not knowing it that I should mention the date also of that order.
Not only date, you have to
Sir,
see.
I have challenged, I have mentioned the miscellaneous application of the Supreme Court in the order.
So,
Sir, I have mentioned the miscellaneous
Confine
application of the Supreme Court's order.
We
It
are
is a
trying-
contempt of court, sir, if the High Court is also not
We
giving
are-
me the documents, sir.
we are trying to hear you on 11/2/2022 and 23/7/2022.
Sir, I will file a writ petition for violation of principle of natural justice in that matter. Sir, until that, sir, I have told this thing, I have told about the 317, which is the application I have filed.
So, 317, basically you want exemption.
Sir, exemption plus there is no conceivable offence is made against me because till now I was not being provided the documents in terms of section 207. Until unless I have been not provided the documents, I am not the accused. Whom should I, sir, one question is that why should I appear? Whom should I cross-examine during the trial proceeding on that day? What was my necessity on that day?
Yes, yes.
What, no necessary was there because I don't have to cross-examine any witness. If just calling me from Karnataka when the COVID-19 pandemic is in stage, sir, Omicron stage was there.
Yes.
Sir, you can imagine, sir, that thing. If any witness, I have to cross-examine the witness, I would have appeared.
Yes.
There is no witnesses, nothing. In the 317 application, I have clearly mentioned that no document has been provided. So it will be my mental torture, harassment visiting the court. Court should have considered that, sir.
So, after, just our query is that,
Yes, sir.
after rejection of your application under section 317,
Sir.
you are participating in the proceedings.
Sir, I approached Supreme Court directly,
For
sir.
last,
Sir, one more thing I want to tell you, sir. That application was filed for recalling of this before the court. After many requests, paying money, the advocate agreed to file that, but never appeared in the Indore High Court for setting aside that order.
we made very simple query, whether after this February 2020.
Sir, I am appearing, sir. I am
You are
appearing
appearing now.
after the Supreme Court's order to surrender me. I have surrendered and appearing, and court has told me, present judge has told me that you don't have to come in every hearing. If you required, you come or your requirement is not there. Clearly he told that your requirement is not there. Because the
at
present
present-
judge is aware that nothing is there against me.
That is the difference. So, at present, this application, whether you are still required to be exempted, you say in view of that.
Sir, I will file. I will file a separate file after this order, sir. If it is being quashed, sir, charges is being quashed, there is no need, sir.
No, what would be the effect of quashing this order?
No, sir, charges against me, sir.
Charges you are not challenging in this.
Sir, I will challenge it in writ petition.
So, you want that this petition should also be taken after that.
Sir, if you take it today only, sir, I will be very happy, sir.
Today
I
I am
don't have to
hearing you. I am asking, so far your exemption application is concerned, nothing remains to be adjudicated.
Sir, my request
In
is
view
there,
of the,
sir.
actually, Mr. Salotia, that's why we wanted the brief
Sir.
written from the state. Ki what is exact? Now he says that he is participating, and the judge has given him liberty that whether he should appear through video conference.
Sir, इसमें-
So whether
Sir,
still you are
there is no
agreeing-
witnesses against me. Whom should I cross-examine during the trial, sir?
That is a different thing. But whether
No
still-
witnesses, no documentary evidence, nothing, sir. It will be a mental torture to me, sir.
Mr. Ashok, whether in view of the subsequent development,
Yes, sir.
anything remains to decide this application.
Sir.
What would be the
Sir,
effect of
sir,
question?
I will give it to the court, sir, to decide on the interest of justice, sir.
No, nothing. If,
Sir, I am
even
giving it
if
to the
this
court, sir.
order is quashed, that this order was wrongly passed, no effect because in view of the subsequent proceeding.
Sir, it
Now
is a
come
Supreme-
to other order,
Yes, sir.
to the other order, which is, that
31,
is
page number 31.
23rd July. What is 23rd July?
Sir, 23rd July, I have approached court that saying that the amount which is being forfeited, the bail, so refund of that cash amount, sir, of 1 lakh, which was
A refund of
refund of the cash amount of 1 lakh, which I have deposited in the treasury, sir.
cash amount of rupees 1 lakh.
So court told that in the last order, it is being forfeited. The
Where is-
1 lakh rupees is being
So
forfeited.
page number 20.
Hmm?
Page number 20.
Yes.
Annexure A. 19 to 20.
हाँ, वापस किए जाने का आवेदन दिया है.
हाँ, sir. So they told it
इसका
can't be,
विरोध
it is being
उनसे
forfeited, the amount will not be refunded.
11 फरवरी को प्रकार जमानत जब्त हो जाने के कारण राशि प्रदान नहीं की उनकी दिनांक
सर 2000 रुपए की जब्ती करी है कोर्ट ने।
सर मैं बोल रहा हूँ सर, मैंने
यस यस इनको बहस कर लें। यस पढ़िए भाई, क्या रिजेक्ट कर दिया ना आपका मिस्टर अशोक?
सर इन्होंने रिजेक्ट कर दिया सर।
क्या लिखे पढ़िए पहला 5 से कुछ
सर
पता-
पेज नंबर 4, आरोपी अशोक तर से प्रस्तुत आवेदन दिनांक 9/7/2022 उसके द्वारा जमानत के रूप में जमा की गई रुपए 1 लाख की राशि को वापस दिए जाने बाबत प्रस्तुत किया गया था, जिसका अभियोजन की ओर से जवाब प्रस्तुत कर लेख किया कि आदेश पत्रिका दिनांक 11/2/2022 अनुसार आरोपी अशोक की अनुपस्थिति के कारण उसकी ओर से प्रस्तुत जमानत व मुचलके जब्त किए गए थे और इस प्रकार जमानत जब्त हो जाने के कारण राशि प्रदान नहीं की जा सकती। So they have refused to give that 1 lakh which I have deposited in the treasury sir.
क्या फॉरफिट कर दिया है क्या?
Forfeit कर दिया सर।
कहाँ पर वेयर इज दैट ऑर्डर? ये 9/7
वो 11 फरवरी को किया सर। जमानत मुचल के 11 फरवरी को जो
11
आदेश है।
फरवरी, यस 11 फरवरी का अभी पढ़ा आपने?
हाँ सर, जो
हाँ 11 फरवरी
सर इट इज इन पेज नंबर 33। अभियुक्त रमेश चंद्रकांत और अशोक द्वारा प्रस्तुत जमानत मुचल के जब्त किए जाते हैं।
सर इसमें 2000 रुपए की राशि उन्होंने जब्त करी है, पेज पैरा नंबर 5 पे उन्होंने लिखा है, पेज नंबर 20 में
मेरे ऊपर तो भरोसा कर लीजिए।
अभिलेख का परिवेशन किया गया। दिनांक 24/3/22 को आरोपी अशोक ने न्यायालय के समक्ष समर्पण कर उक्त दिनांक की आदेश पत्रिका अनुसार उसकी मुचलका राशि में से 2000 रुपए की जब्ती की जाकर उसे 1 लाख रुपए की नई जमानत और इतनी ही राशि का नया मुचलका पेश करने पर छोड़ दिया गया था।
वही अमाउंट एडजस्ट कर दिया
हाँ,
है।
2000
सर
रुपए
नहीं
जब्ती
सर,
करे हैं।
नहीं सर एडजस्ट नहीं किया है। मैंने उसी 1 लाख के लिए आवेदन डाला था जो सर ऑर्डर जो पास हुआ है सर ऑन
ये उल्लेखनीय
23 जुलाई
है
को
कि पूर्व का जमानतनामा
23
आदेश
जुलाई को जो
पत्रिका
मैंने
में
आवेदन
जब्त
डाला
किया
था 1 लाख रुपए मांगने के लिए, जिसमें जज साहब ने लिखा हुआ है, जज साहब ने लिखा हुआ है पैरा 4 में सर मैं 1 लाख रुपए वो मांगने के लिए कोर्ट में गया था। 2 लाख का मैंने अलग से सर जमा किया फाइन, और ये जो 1 लाख रुपए जो फोरफिट हुआ वो मांगने गया था सर मैं। तो उन्होंने बोला कि ये फोरफिट हो गया, नहीं मिलेगा आपको। अब 1 लाख रुपए छोटी
ये क्या लिखा
रकम भी नहीं है सर।
उन्होंने? कि 2000 रुपए की जब्ती की जाकर
हाँ, ये 5 पैरा नंबर 5 में सर क्लियर करा है उन्होंने।
इसको फिर से डिसाइड करना।
सर आप अगर 11 फरवरी को ऑर्डर
वेग है ये ऑर्डर जो है।
सर इसको सेट असाइड कर देंगे तो मेरा जो भी डिसाइड
वी आर ट्राइंग टू अंडरस्टैंड।
यस सर।
सर इसमें हुआ जो इस ऑर्डर से पढ़ के लग रहा है ना कि ये पहली बार जब
आपको जमानत कितने 1 लाख रुपए की थी?
सर एक्चुअली मैं बताऊं तो सर आप भी सरप्राइज होंगे कि मुझे जमानत 25 लाख में दी गई थी शुरू में, वो भी शिवपुर का साहब ने दिलवाई थी सर। मैं जेल के अंदर था, 25 लाख कैश और 25 लाख श्योरिटी, 50 लाख का ऑर्डर दिया था। मैंने उसको चैलेंज किया सर, तो उसको वापस 1 लाख में कर दिया गया, वो रिफंड किया गया और मुझे 1 लाख में दिया गया सर।
मतलब 1 लाख रुपए।
उसके लिए मुझे घर बेचना पड़ा मुझे सर, घर बेच के वो 50 लाख 25 लाख रुपए कैश जमा किया मैंने घर बेच के, और 25 लाख की किसी से महीने के 10,000 रुपए में वो मैंने जमा किए सर। वो लोकल यहाँ का है ना सर, वो एग्रीकल्चर लैंड रख के मैंने किया सर। मैंने बहुत तकलीफ सहा है सर इस चीज के लिए।
ये तो वेट है, इट्स नॉट क्लियर कि 2000 रुपए की जब्ती की
हाँ,
कि
उसमें
1
सर
लाख।
इस ऑर्डर से पढ़ के ये लग रहा है कि पहली बार जब ये कोर्ट में हाजिरी पे नहीं गए
ये
तो
तो
कोर्ट ने इनकी पुरानी वाली जमानत जो थी वो जब्त कर ली, और वो जब्त करके नई 1 लाख रुपए का फ्रेश बॉन्ड इनको भरने के ऑर्डर करे, जिसमें 2000 रुपए जब्त करके 1 लाख रुपए एडजस्ट कर दिए। ऐसा इस ऑर्डर से पढ़
नहीं 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 सर, नहीं मैंने 1 लाख का FD
क्लियर
जमा
नहीं
किया।
है।
1 लाख का FD जमा
कर
किया।
सकते हैं सर।
लिखिए।
सर ये ऑर्डर अगर सेट असाइड कर दें तो मुझे पूरा पैसा मिल जाएगा। एक
नहीं ऑर्डर फिर से डिसाइड करेंगे।
But sir-
को क्लियर नहीं ऑर्डर
सर ऑर्डर सर आपके सामने, क्योंकि ना तो मुझे कोई नोटिस इशू की गई है कि भैया
नहीं, आपको सुन के
आपकी हम बेल कैंसिल कर रहे हैं।
आपको सुन के करेंगे। यस लिखिए। लिखिए बाय ऑर्डर डेटेड 11/2/2000 लिखिए। Thus the present petition is confined to challenge to the order dated 11/2/2022 and 23rd July 2022. देखिए, by order dated 11/2/2022, the application filed on behalf of the applicant.
सर इसमें ऐसा भी जो 1 लाख रुपए पिछली बार जो उन्होंने भरे हैं ना, वो कंडीशनल बेल थी इनकी।
अब और सब देखने दीजिए, रिकॉर्ड देख के मत।
ये जो 1 लाख रुपए
Judge will
भरे हैं, ये बेल
decide
बॉन्ड है।
because we don't have the entire record and the order seems to be not
सर
very
रिकॉर्ड सब
clear.
सबमिट किए मैंने सर,
ठीक है, वो डिसाइड
जो मैंने 1 लाख जमा किया कैश ट्रेजरी
Yes.
में, उसका रिसिप्ट जमा
लिखिए।
किए मैंने।
The application filed on behalf of the applicant under section 317 of Code of Criminal Procedure for exemption from personal appearance and condonation of non-appearance on the previous date has been rejected. Full stop. Counsel for the applicant submits that the said application was moved on the following ground. ये ए लिखिएगा यहाँ से, जो इनका रिस्क एंड थ्रेट टू लाइफ और लिखिए, ये ए उतार दीजिएगा, लिखिए। It is stated by applicant that after the order dated 11/2/2022, he is participating in the proceedings and the presiding officer has given him discretion, either to appear in person or to appear through video conferencing. Full stop. In view of the aforesaid, nothing remains to be adjudicated. The validity of impugned order dated 11/2/2022, so far it relates to challenge to the rejection of application under section 317 CRPC. लिखिए, by order dated 23rd July 2022, the application filed by the applicant for refund of security amount of rupees 1 lakh has been rejected. Full stop. It is submitted that by order dated 11/2/2022, the bail bonds of the applicant was forfeited and thereafter he was granted bail after surrender on 24/3/2022 on furnishing rupees 1 lakh as a fresh security. Full stop. The relevant para 5 of the impugned order reads as under. ये कोट कर दीजिएगा, फ्लैग ए, पैरा 5. देखिए, on going through the order dated 23rd July 2022 and para 5 of the order, it is not clear that what amount of bail bond has been forfeited. Full stop. In the above para, it is mentioned that rupees 2,000 was seized and adjusting the same, he was released on bail of furnishing 1 lakh rupees security. Full stop. In view of the aforesaid, the impugned order, so far it relates to rejection of the application for refund of security amount is set aside and the trial court is directed to decide the said application afresh after affording opportunity of hearing to the parties without being influenced by the order dated 23rd July 2022.
सर, if 11 फरवरी का ऑर्डर ही सेट असाइड हो जाता तो सर मुझे अमाउंट मिल जाती
वो
है
उसमें कुछ नहीं है
सर।
exemption है।
2000 क्योंकि वो
वो अब
गलत
कोर्ट-
है सर, वो ऑर्डर ही
कोर्ट-
गलत है सर।
You have to cite the law whether forfeited amount can be refunded or not.
नहीं सर,
This-
ऑर्डर ही गलत है ना सर वो।
So
मुझे
that
वही बोला था कि
everything-
ऑर्डर गलत है सर वो।
Everything will be required.
सर वो ऑर्डर के लिए मुझे सुप्रीम कोर्ट जाना होगा उस ऑर्डर के लेके। इलीगल अरेस्ट, मेरा अरेस्ट वारंट निकाला, इलीगल अरेस्ट, आई हैव टू फाइल ए केस अगेंस्ट द
वो
दीपक
करिए
गुप्ता
ना।
सर।
अभी तो
सर,
कोर्ट को
ओके
कह
सर।
दिया, आपको दोबारा सुन के
सर,
फिर
ठीक सर।
रिफंड के लिए आपको सुनेंगे।
ठीक है सर।
Yes, with the aforesaid, the application for 482 application is disposed of.